Welcome back, clever home buyers. So the REIQ Contract of Sale. And so the REIQ is the Real Estate Institute of Queensland, and they got together with the Queensland Law Society to be able to make a contract that is easy to understand, it's got everything in it that you need, and it protects the seller and the buyer. It's important to remember that the real estate agent is not on your team. They'll have you sign a contract geared towards their client. This is going to be a lengthy video, but I'm going to keep it as simple as possible, and I'm going to try and keep it less than 10 minutes. We're talking about the REIQ Contract of Sale. To begin with, I'm showing you this page out of the workbook because the REIQ Contract of Sale was created by the Real Estate Institute of Queensland and the Queensland Law Society. They decided that it would be smart to make a contract that protected both the buyer and seller. It was a standard contract. It is a standard contract that includes everything that needs to be in a contract to buy a home, and it provides for a lot of flexibility. You can put this in, take this out, change that, put in what you think is right, blah, blah, and then you sign it, and that's the contract. So it's a great idea. I'm going to take you through it because we need to talk about the flexibility that's in that contract and how you can make it work for you if you're in a situation where you are able to make some modifications. And what I mean by that is if it's a seller's market in a hot market and there's several offers come through and some of them have got cleaner contracts than yours, provided that the dollars are about the same, they're likely to go with the cleaner, simpler contract. But if you're placing an offer on a home and you're the only offer, then you've probably got the ability to negotiate a bit more favourable contract terms for you. Let's talk about it. So the real estate agent is not on your team. We know that. They will have you sign a contract geared towards what the seller wants. Your conveyancer is on your team. And a conveyancer can advocate for you and negotiate more favourable terms and conditions before you sign or at any point during the process. So a common agent process is to gather offers and then help the seller to choose the best one. If your offer is accepted, you're in a strong position to have your conveyancer refine the contract a little bit to your advantage where possible before you commit. Most of the people out there are submitting offers and then they're signing a contract afterwards. We strongly encourage you to speak to your conveyancer regarding anything in the contract, any special conditions or anything that you want to add before you sign the contract. And it's essential you're prepared before you sign anything. If you are ready to show the contract to your conveyancer, they're going to need this from the sales agent, all of the relevant property documentation. You know, when you go to those open homes and they take down your phone number and then you get sent a text message afterwards with a link in it. You click on the link and you take into this web page with all of these documents in there. Just send that link to your conveyancer. That's great. That's easy, simple. And then from you, your conveyancer will need information like all your personal details and your offer price and your terms and any special conditions. And you're like, what am I going to? So I'm going to help you to understand what terms and special conditions you can put into the contract because you don't know what you don't know. And if you're unable to instruct your solicitor or conveyancer because you just don't know what you could be instructing them to do. So let's make you aware of that. Having said that, this information in this module is not advice. It's just general information to help you understand the REIQ Contract of Sale. So you can then give instructions to your conveyancer. So the REIQ Contract of Sale, I was saying before, it's a template, but it has flexibility. Flexibility for the seller and flexibility for you. These are the points of flexibility in the REIQ Contract of Sale. The first one is excluded fixtures. What's the seller taking with them? The next one is included chattels. What is it that you want them to leave behind? Another one, the purchase price. This is the obvious area for negotiation, but that will be stated in the contract clearly, as will your deposit. And we'll talk about deposits in a little bit more detail, but buyers might offer a small deposit or sellers might request a larger one. The combined amounts cannot add up to more than 10% of the purchase price in Queensland. In a seller's market, a larger deposit may demonstrate your commitment. However, if you cancel the contract during the 5-day cooling off period, you may lose a percentage of that deposit. All right, so we'll flesh all of this out. Another area of flexibility that you've got in this templated contract is finance. You might not have that much cash sitting in your bank account. You might need to get money from a lender, and therefore you want your contract to allow you to have that leeway so that you can go and apply for your money from the lender, have it put into your bank account, or have the lender pay it into the seller's bank account. This is where pre-approval is very important, because if you haven't got pre-approval, your offer doesn't look very attractive to the seller. So make sure you've got your pre-approval in place so that therefore you can then say, yep, I'm pre-approved and it's going to take me 2 weeks to get that money through to you from my lender. Basically, that's what that means. It's important that you answer that clearly on the contract, and so we'll talk about that. Another area of flexibility, finance. You could have said, no, I don't need finance, and you could have just left that blank. Another one you can leave blank is the building and pest inspection. I wouldn't encourage it unless you're 100% confident that you don't need it, or that you're 100% confident that they won't accept your offer unless you've left it off, in which case you need to have done other physical due diligence so that you feel comfortable making an offer by leaving that building inspection information blank. And we'll talk about that as well. Special conditions. So that's a catch-all for any other agreed upon terms that aren't covered by the standard clauses in the templated contract. Another one is the settlement date. When do you actually want to pick up the keys? Does the seller want to stay in the home for a period of time, and so you've got to wait for a period of time before you can pick up the keys, or are they not even living there, and so you could pick them up almost immediately as soon as all of the contract conditions have been met? So the settlement date, quite often it's 30 days. It could be less, could be more. And any annexes that are attached to the back of the contract. So these are the things that, from that contract template, these are the things that are negotiated and are ebbing and flowing until those signatures go on there. So what I want to do is show you a contract so that we can see where these flexibilities sit within that contract. Let me take you to the contract. On the front page of the contract, we see that it's all about the seller. We've got the seller's real estate agent's name. We've got the seller's names, Bronwyn and Jay, and their solicitor would be listed there as well. On the second page, we've got the buyer's details. That's blank because they don't know who's going to be buying the home. So that's your name. If there were more than 2 names here, you'd put the third name as an annexure at the end of the contract. Your buyer's agent, if you had one. If you're studying my online course and you've not hired me as your buyer's agent, if I'm just teaching you or coaching you, then you would leave that blank. Your solicitor will go here. That's your conveyancer or solicitor. And of course, the property address is here. This detail here is particularly important, the title reference, as is the street address, the entire address. You don't want to buy someone else's home. So that's page 1 is all about the seller. Page 2 is all about the buyer. Page 3, this is where we start to see the flexibility in the contract. It could be laid out more pretty, I know. But once we get past the ugly layout, for those of you who use Canva or are graphic designers, we get to see the flexibility within this contract. And so this point here, they're asking you the excluded fixtures, the things that the seller is taking with them, the included chattels, the things that the seller is leaving behind. Good, that makes sense. This part is about the price. The deposit holder, that will always be the real estate agent, and it's their trust account. So the fact that we don't have these details yet is not that important. The purchase price, however, that is the price that you are offering or have agreed to pay for the home. Now, the deposit, we go into deposits in more detail in a separate small video. Basically, the deposit, if you fill out a form, that's this. That's your deposit. So what we do is we break it into an initial deposit and a balance deposit. Generally have the first one smaller than the second one. And we talk about deposits in an extra video. The next thing is finance. If you're not seeking finance approval from a lender, you don't need to fill this in. If you are seeking finance approval from a lender, you need to fill in each one of these 3 lines. If you omit one of these 3 lines, it doesn't work. We need to know all 3 bits of information in order to make this contract subject to finance. And so therefore you can read it here unless all of these 3 amounts, these 3 lines are filled out, the clause does not apply. So you want a finance clause, you make sure you fill out each of those. If you're confused, speak to your buyer's coach or your conveyancer. Building and pest inspection. Leave this blank if your contract will not be subject to a building and pest inspection. If it is subject to a building and pest inspection, you need to put the date that you will respond to the seller by. So, for example, if this contract is dated the 10th of July and you want a 7-day building and pest time frame, then the 17th of July would be the date that goes in here. Again, if you have a look at when you made an offer, it's going to say it's subject to building and pest, and it's going to ask if you how many days. Okay? Matters affecting the property. So, title encumbrances. What is an encumbrance? Okay, so an encumbrance is something that has a claim to that title. There's probably a better description of it towards the back of the book. Let me find it for you. Definitions, encumbrances. All right, encumbrances include unregistered encumbrances, statutory encumbrances, and security interests. Well, it doesn't really, does it? Your conveyancer is the best person to describe that for you if you find something written in this box. So I see written in this box is something to do with sewerage. I'm like, and it's a yes. Yes, there is an encumbrance and it's got something to do with water or sewerage. The best place to go to find out about that is if there is an encumbrance, there should be an annexure attached to the end of this contract describing it. Let's have a look. Oh, there is a document here saying, so the blue lines here are water pipelines and the red lines are sewer pipelines. So we can see there's a sewer pipeline. This is the block number 2, Kilcoman Street. There's a sewer pipeline runs through the back of the block. This is the front. You can see the mains water is here and the water that's coming onto the property is here. There we go. So now we know what that means because they've attached it as an annexure. What else do we have? Let's go back. First page is all about seller. Second page is all about the buyer and the information about the property. The title reference. So we have an annexure to this. There was only two annexures to this contract. And this is the other one. So let's just check 150412228. 150412228. And that's from Titles Queensland. So we can check that this is owned by those people. So it must be the same block of land. And it doesn't have the address. Do you notice that? It's got the title reference number. So we check the names. We go, okay. You can see that there's some other encumbrances mentioned here. So they've obviously still got a bit of a mortgage going on there. Your conveyancer will be the person to make sure that that gets paid out before you own the property. So page 1's all about seller, page 2's all about the buyer, page 3's got a lot of the flexibility that we talked about here, a lot of this flexibility. So what haven't we talked about yet? We haven't talked about special conditions. We've covered the fixtures, the chattels, the price, the deposit, the finance, and the building and pest inspection. Special conditions. Okay, let's have a look. We have to go through 2 more pages to get to the special conditions. So these special conditions are, there's actually some special conditions in this contract. And so if you're not a conveyancer, I would get your conveyancer to read these. I happen to know that these are fine. However, I just recommend you get your conveyancer to read about the special conditions. Settlement. So we go back to this document. We see after special conditions, we've got the settlement date. Settlement date is here. And when you filled out your offer form, you would have said settlement, 30 days or other, and some specific date. You know what's a good tactic? You just say, if it's of no concern to you, you can just say, within 21 to 60 days, I'll let the seller choose. If that's fine with you, then why not? That's going to make your offer that little bit more attractive without having to negotiate that. All right, so that's the settlement date. And then the annexures are after that. So obviously I have to go through all these little definitions and the annexures you've got to. So there were a couple of pages in there, weren't there? Let's go to them. So let's start again. Page 1 is about the seller. Page 2 is about the buyer with the property details down here. Page 3 is about some of the flexibilities. Page 4 and 5, they kind of snuck in there in between the special conditions and the settlement and the signatures. Let's talk about them. If your home that you're buying has got a tenant living there, this is really important. So this one, there's no tenant. But if there was a tenant, wow, we need to know all of this information here. Because if you're buying a home and there's a tenant in place, the last rental increase is very important to you, because a tenant can only have its rent increased once every 12 months. So you need to know how much rent they're paying, and you need to know who's looking after them if there's a tenant in place. No point buying a home you want to move into if the tenant isn't going to move out for 6 months. Is there a pool on the land? The answer is no, so wow, that's easy. If the answer is yes, then we need to look at the pool compliance. We have another video. It's at module 4, where we look about our physical due diligence. Same with the electrical safety switch and the smoke alarm. Make sure that you watch that in module 4. Neighbourhood disputes. Seller is saying that the property is not affected by any disputes regarding dividing trees and fences. Okay, next page. This is only pertaining to the fact that if you were going to be, okay, this GST bit on this page is about whether or not the buyer is registered for GST. In other words, are you claiming it as a business who is registered for GST? The answer is probably no, unless you are. And then if you are you required or not required to make a payment of GST because of this purchase? And that's it. We do have all of these terms at the end of the contract, which are there to help you to understand everything we just spoke about. I do have a couple of sample offer forms here. This one is one for Harcourts, and they do not ask you to sign it. They're asking you for your name and address and information. They do have down here at the bottom any conditions if required. So if you're placing an offer and you want it to be streamlined and tempting to the seller, you would just say no, no, no. The trouble is that would be very tempting for the seller because that's a very clean offer. And if you're bidding for a home at an auction, it'll be under that. It'll be like that. There'll be no terms like that. So when you place an offer, you get to write it on an offer form, or you get to stipulate this information on a contract. Let me find another one. That's another way of expressing an interest or placing an offer. And you'll notice at the bottom of this one, it does ask you to sign it. You don't have to. There's a Ray White one, and you can see that they do have a buyer signature here, although it's not important. If you find that there's more than one person making an offer, they must ask you to sign this form here, which is simply proving that they told you that there was more than one person submitting an offer on this property. Because it's so important. I mean, if you think you're the only person placing an offer on that property, then you're going to sit back and wait for them to contact you because you think, wow, I've placed an offer. Now they're just thinking about it. Well, actually, they could be thinking about 3 or 4 other offers that they also received. And so you need to. So the sample special conditions that I've got here, we go to the blank contract and we go back to the area where we have these special conditions that we can list here. I want you to be aware of exactly what special conditions you could ask your conveyancer to put there. Always ask your conveyancer to word them for you. And an electrical special inspection condition. So you might be conducting your physical due diligence and you might think that the electrical system to the home is not in very good condition. In fact, it looks like it's from 1961. So you might say to your conveyancer, I'm concerned about the electrical condition, the condition of the electrical system. Can we put in a special condition that says that, for example, the buyer can request an electrician to check the wiring and electrical systems within 5 days? Or a contemporaneous settlement condition. So this coordinates the settlement of 2 property transactions to occur simultaneously. For instance, the buyer you're purchasing a new home, but it's this home, the one you want to buy with this contract, but you can't buy it until you've sold your first home, the existing home that you own. So you could ask your conveyancer to say, well, actually, I don't want to be contracted to buy this one if this one doesn't sell in a certain period of time. That's what that means. Your conveyancer will word it appropriately. Pet approval condition. So imagine you're buying a unit in a set of units and you want to find out if you can have a dog, or you need a special condition so that you can have that approved, because you don't want to go buy a unit if you have to give up your beloved best friend. That would be very uncool. A soil test condition. Perhaps you want to do something with the property after you've bought it, but you're not sure if you can because you need the soil test to determine if you can do that with that block of land. Subject to sale condition, very similar to the one that we listed above. However, your conveyancer will potentially name them differently or word them differently. The due diligence condition. Now, this can be a catch-all. And if it's not a hot seller's market, if it's a buyer's market, you can actually put a special condition, which is a due diligence condition, saying something like you require a due diligence period of 14 days to conduct your due diligence and verify other things. What is your due diligence? I don't know. You can just say due diligence. If it was a seller's market and they received multiple offers, they're probably not going to like that being in a special condition of the contract, because it opens them up to a lot of, well, they don't know what your due diligence will be. So it could be anything from checking the tree roots to, for example, a third could be a due diligence clause providing 21 days for the buyer to assess the property's suitability for a specific business use. So that's a catch-all condition, which can be quite powerful for a buyer if it's in a buyer's market. Other sample special conditions is a sunset clause. Now, I would never begin to even attempt to word this correctly. However, an example of a sunset clause, quite often they're used for off-the-plan properties, okay? So these are homes that are sold before construction is complete, such as apartments, townhouses, or house and land packages. And the sunset clause sets a deadline for the developer to complete the construction. So you've put your deposit down on a house and land package and you're supposed to have it finished within 18 months, and it's not. So then you can get out of that contract because the home wasn't ready for you. That's one way that you can do it. I think they've recently changed it because there were developers who were cancelling contracts because the the prices of property had gone up so much recently that they were not making as much money as they could. So they were using it to get out of contracts that way and then resell them to other people who were going to pay more. Early possession allows the buyer to take possession of the property before settlement. So that means that, okay, you've got nowhere to live and the sellers don't live there anymore. So they're saying, okay, in the contract, you can move in before settlement. We don't mind. That is something that could be put in as a special condition. Another one is a rental guarantee. So the sellers might stay on and rent the property from you for a while. Maybe you outline that could be 6 months or 6 weeks, paying you rent whilst they stay living in it until they move out. Maintenance. So a special condition in the contract might be that the seller has to conduct specific maintenance responsibilities before settlement, and that's just outlined in the contract. And so I've also got a link here, and amazing, this link. It is by 2 different conveyancing firms, and you can hop in there and have a look at their special conditions that they have actually worded in terms that conveyancers use that you could copy and paste into your contract. It's not what I'd recommend, but you can have a look at that, and that might give you some insight into what you can then request your conveyancer to put into your contract, because I'm just making you aware of it. They are making you aware of it. It's up to you to go and make your own conveyancer aware of it. Okay. Now, that's enough about the special conditions in a contract. I'm now going to cover the cooling off period and do that in a separate video. This video is about the cooling off period. So in the REIQ Contract of Sale, the buyer is granted a 5-day cooling off period unless the contract is under auction terms. And what that means is that there's no cooling off period. Under the fall of the hammer, you've bought it, whether you can afford it or not, whether you can get loan for it or not, whether you haven't conducted a building and pest inspection, it's riddled with termites or not. You've bought it under the fall of a hammer at auction. There is a cooling off period if you have bought it under any other condition, unless you waived that cooling off period. So in Queensland, a cooling off period of 5 business days starts the day the contract is signed by both parties. For contracts that arrive on a weekend or a public holiday, the cooling off period starts on the next business day. The cooling off period still begins if a representative signs on the buyer's behalf. So if you had your buyer's agent sign on your behalf, it still starts at the same time. If there's a dispute, the seller or their agent, the sales agent, must prove when they delivered the contract and it was signed. So you can imagine if you think you've got 5 days in your cooling off period, and at 5 p.m. on the final day, you say, okay, yep, sorry, I want to take advantage of the cooling off period and cancel the contract. And they were like, no, that was yesterday. So you've got to be quite clear on that. Your rights under the cooling off provision in the REIQ Contract of Sale allow you sufficient time to investigate the property or rectify issues with the contract, particularly if you have any concerns about the property, including the property value. You may also wish to fully investigate any insurance issues in relating to the property, including cost and availability of insurance. However, if you exercise the right of termination pursuant to the cooling off provisions, the seller may retain a penalty of 0.25% of the purchase price from the deposit paid under the contract. Do some maths. So if I get out my trusty calculator, which, I'm a calculator girl, I'm old-fashioned. So say it's a $1 million property, and we want to know what 0.25% is. That's $2,500 that they can keep from your deposit if you pull out during the cooling off period. If you do have concerns about the home and a cooling off period applies, you can urgently instruct your conveyancer to immediately commence some searches before the cooling off period expires. Exempt contracts, a sale by auction, like I said, or a follow-up sale after an unsuccessful auction before 5 p.m. on the second business day after the auction, in which the buyer was a registered bidder. If you weren't a registered bidder, then you get the cooling off period. So to cancel the contract of sale, you must give the sales agent, the real estate agent, notice in writing by 5 p.m. on the 5th day. You can deliver it in person or by email. If you choose to cancel during the cooling off period, the seller may deduct that penalty and they will need to refund your deposit. And they may obviously take that percentage out of the deposit. If you then later decide you would still like to purchase the property, there is a risk that the seller will not be willing to enter into another contract with you. So involve your conveyancer from the beginning if you think you need to take advantage of your cooling off period. Welcome back, clever home buyer. This time I'm talking about deposits. So this video is about understanding deposits. And they can be a little confusing. Most people pay 3 deposits. The first one is the initial deposit and the second one is the balance deposit. That is the amount that you say when you place your offer, this is my deposit. It's broken into 2 amounts. Okay? So in order to explain this in a little more detail, I'm going back to that contract that we had before, the blank contract. And down here, you can see it says initial deposit, and then it says balance deposit. The initial deposit is due when you sign the contract. The balance deposit is usually paid when the contract goes unconditional. That means that all the conditions on the contract have been met and we're just waiting until settlement occurs. Generally, there's a bit of a celebration when the contract goes unconditional because unless something goes wrong at settlement, usually we're there. So your deposit, this amount, is broken into an initial deposit and a balance deposit. And let me show you. So if you make an offer, it's asking you for your deposit. That amount there is this amount here, broken into 2 areas. Now, how do you know how much to put in either? I know. So let me explain first a little bit more about what each one is. So I'll go back to our workbook. The initial deposit is a refundable deposit when you sign the contract. This deposit is paid within 24 hours of signing the contract and it's paid into the real estate agent's trust account. They will let you know what to pay and when and where. And what to pay depends on what has been placed into this area of the contract. Now, the balance deposit, once the contract goes unconditional, you pay a second deposit to the real estate agent. So you're like, okay, well, how do I know which is which? You can let the real estate agent fill that in the contract for you. You can let your conveyancer fill that in the contract for you, or you can fill it in yourself. If you need help to fill it in yourself in this workbook that we're currently in, if I was to fast forward you all the way to the bottom of the jar, we make up a worksheet for you so that you can therefore say the price of your offer, the initial deposit and the balance deposit. Here we recommend this much and this much if you're not sure. This is the last page in the workbook before the end of the workbook, okay? So we try and make it clear for you and we will get to that. So understanding the deposits, the final deposit that you'll probably find that you're paying if you're receiving finance is your lender's deposit, and that's the one that does not go to the sales agent. It goes to your lender, the bank, the building society. Your mortgage broker will have liaised if you have a mortgage broker, and then your conveyancer will probably take care of making sure that you don't miss any of these dates. A good one will. They'll be emailing you in advance. Don't forget, you've got to pay this deposit coming up because this is when the contract goes unconditional. You've got to transfer the money. This is the amount. You need to be really careful of scams nowadays when you're transferring big amounts of money. So be guided by your conveyancer because they will be the ones that are protecting you from transferring the money to somebody who doesn't deserve it. Right, so that's what we have to tell you about deposits. And I can't wait for the next video because then we're really going to go into a lot of detail about avoidable contract mistakes. I'll see you then. So you might be wondering what mistakes could possibly be in a contract that could throw things awry, many, and they're avoidable. One of the most common ones is not getting the names right on the contract. And believe it or not, it's very important. So you can't use nicknames. If your name is James, you can't use Jimmy or Jim, for example. If your surname is a double-barreled surname with a hyphen, but everyone just uses the first part, that's not good enough. Whatever's on your Medicare card isn't necessarily what's on your passport. So it really needs to have your legal name on the contract. And so that's important. That's an avoidable mistake. Another avoidable mistake is missing deadlines. All right. So failing to have your building and pest inspection report in by the deadline is a common one. The buyer may lose their deposit if deadlines are not met. That's enough reason to make sure you meet your deadlines, isn't it? Not including chattels and fixtures in the contract, just assuming that the shelves in the garage are going to stay. Just assuming, don't assume. Look, it happens more often than we'd like. Sometimes the seller will take the dishwasher with them and you assumed that it was a fixture, whereas it can be unscrewed and unplugged and wheeled away or shimmied away. But just make things clear. If you expect them to be there when you get your keys, make it clear in the contract. Ignoring the sunset clause is another one. Misunderstanding the cooling off period, not realising the cooling off period exists, for one. Failing to act within the cooling off period. Misinterpreting the length of the cooling off period. So understanding that, because you may be expecting you can terminate under the cooling off period and you missed it because it's 5:15 and you had to have your cooling off period ended at 5 p.m, for example. Okay, next page. More avoidable contract mistakes. Overlooking the finance contingencies, not including a finance clause in the contract. Now, as we said about the contract before, if you don't have each one of these lines, this one, and this one with information in it, then you'll find that you've not included the finance condition in the contract. Failing to seek legal advice and signing the contract without legal review, misinterpreting the jargon, overlooking important things. Wow, you might get unfavourable contract terms, or it could actually be a lot worse than that. So you need to always make sure that you either understand precisely what's in the contract or that you seek legal advice. And my advice to you is always seek legal advice. You know, there are conveyancers now I'm sounding like I'm really old. Go to a conveyancer and they'll say, this is our set fee, and in that we will peruse 3 contracts for you. Okay, but still the same amount. So why not? Disregarding special conditions, failing to specify required repairs or not including conditions for anything. We talked about the special conditions in a previous video, and so not paying attention to the ones that are already in the contract or not including ones that you should have had in the contract to protect you and your interests. Misinterpreting the terms of sale. So misunderstanding the settlement date. Okay, so you thought that you were moving in on this date and that was the unconditional date. You got confused, or getting confused about the deposit, overlooking the current cooling off period. So misunderstanding the inclusions and exclusions, and make sure we understand the terms of sale. Failing to include the annexures. Remember that contract we showed you earlier had annexures in it. Making sure that that information is included in the contract. If in doubt, obviously your conveyancer is your best friend in this situation, clearly. Please don't ask me about contracts when we have our coaching call. Not my job, because I don't want to misguide you in the slightest. That's what they're for. I can give you general information, but that's all. Overlooking title issues, okay? Not verifying the property's title. We talked about that before. When you open up a contract and you're looking at the front page of that contract the second page, and we're looking at the title reference number here, the sales agent may have put that incorrectly, in which case you've just bought somebody else's land. It's not that stupid. It's not that funny. Okay? Let me read what's written here. Not verifying the property's title, overlooking easements and encumbrances. ignoring boundary disputes, failing to check for outstanding mortgages or liens. Problems cause legal disputes over property ownership. Right. There's more avoidable contract mistakes. Incorrect deposit handling. Okay. So not paying the deposit on time and paying the wrong deposit amount. Failing to provide proof of payment and not understanding the refund conditions. Okay. So yeah, I mean, you might not get all your deposit back. Just understand that. Inadequate insurance coverage. Okay. Did you know that the day after you sign the contract, you have until 5 p.m. to take out insurance on the property that you don't own yet, whether that be a block of land or a house or a unit? If something happens and there's an insurance claim that needs to be processed, if you're not insured, that's a really big problem for you. I'm talking about if it's a block of land and there's a tree on your block of land, and in Cyclone Alfred, for example, that tree fell on and crushed someone's house and you don't have insurance on that block of land, that's going to be a legal situation for you. What happens if it's not a block of land, it's a house that you've just bought? The seller's still living in the house, but it floods or it burns down or a tree falls on it or a car runs into the fence. There's many reasons why you need your own insurance. And I think we definitely covered this in another module. I think it's covered in module 9 completely. But yes, you are responsible for the property 5 p.m. the business day after you sign the contract. Unclear occupancy terms that are not made clear. You haven't understood them in the contract. That means that you thought you could move in and you can't, or you thought the tenants were moving out and they're not, or you thought the sellers were not still going to be there when you picked up the keys. Ignoring maintenance responsibilities. Okay, so the seller didn't maintain the pool. The pool went green and you came in to move into the house and this pool is like soup. Well, that's property, because if there was a special condition in the contract that the seller was supposed to maintain that pool and not let it turn into green soup before you picked up the keys, that's problem. Miscommunication between parties. The last one here on this page is not informing the seller of your finance approval, failing to communicate inspection results. Okay. If you weren't happy with the building and pest inspection results, but you didn't tell them and it's too late, the date's passed, you can't get out of the contract. Okay, so the building is unstable and almost going to fall down and you have missed some dates and not sent that building and pest inspection report to the seller by the due date. Ouch. That's a legal situation that you don't want to be in. Okay, so they are the avoidable contract mistakes. I'm highlighting these for you so that you treat contracts with the care and respect that they deserve, and you involve your conveyancer whenever you have a bit of an eyelid flutter about, what does this mean? I don't understand. Okay, nice to see you again. I'll see you in another video, no doubt, very shortly. This is just a very short video talking about contracts for auction. So the REIQ Contract of Sale is still used at an auction, but it doesn't have the same degree of flexibility that the normal REIQ Contract of Sale has. That's because when you sign the contract of sale and auction, you're signing the contract the way that it is already. So you need to have already viewed that contract and have your conveyancer view that contract, and you need to be satisfied that you are happy with any special conditions in that contract or any terms in that contract. So let's have a look at what could be different. So sometimes also it's good to bear in mind is that you might say, I want to put an offer in before auction. And the sales agent might say, fine, but it'll be under auction conditions. And what that means is there's still no cooling off period, even though you've put an offer in before auction. They want you to have, let me explain it better. The seller is going to auction, right? And they know this is the contract that is going to be signed by the winning bidder at the auction. And so if you're going to put a pre-auction offer in, they want you to sign this contract too. Otherwise, why would they bother? They can just wait for you to bid at auction. If you're going to have conditions, they're not going to really be interested unless, of course, they feel like maybe it's a real buyer's market. No one's going to turn up for the auction. There could be other reasons, but generally let's just approach this with the solid knowledge that if you're going to place an offer on a home that is headed for auction, they're going to want you to have an auction contract, a contract that has got the same terms and conditions. I hope I made that clear. If there is an auction to take place, the contract will be made available for you to review well in advance. Get it immediately at the open home. Don't wait. Quite often when you attend the open home, you'll receive a text message. The link to all of the documents for the property will be on that link. So the link will take you to a web page and all of the documents for that property, including the contract, will be on that web page. If there's anything in there that makes your eyelid flutter, you need to have your conveyancer have a look at that before you go to auction. If you need special terms, an auction is probably not going to work for you. The reason that they're selling an auction is because they know that more than one person's interested. However, you may be able to get the seller to agree to them prior to auction. Otherwise, what's the point in bidding if you need a long settlement and they won't give you one? So find out from the seller, ask your conveyancer to ask them if it's possible that you could have maybe a different settlement term. Don't really have anything else that you want to put differently in that contract. It's biased towards the seller. It does take a bit of liaising between parties should you want to do that. However, if you're the highest bidder on the auction day, it'll be subject to the terms in the contract that you negotiated prior to the auction. Please don't get excited about that. It's probably not going to be something that the seller is interested in doing. So why is contract review essential before a Queensland auction? In Queensland specifically, there's no cooling off period, right? You know that 5-day cooling off period that we talked about for an entire video doesn't apply to an auction. If you're the successful bidder after the fall of the hammer, you are legally bound to complete your purchase regardless of whether you can afford it or have had time to fully research the home. It's also an unconditional contract, like I said. Any conditions in there will be the ones the seller put in there. So that's why you must show your contract to your conveyancer before you bid in case they do have something in there. The standard contract may have potential variations. Whilst the REIQ contract is commonly used, sellers can include special conditions or variations that might not be immediately obvious and could significantly impact you. So just if you're turning up for an auction, don't just rock up and go, oh, that's the stock. I bought the house. Oh, sign the contract. Make sure you've looked at it before you buy it. The deposit settlement. The contract will specify the deposit amount and settlement period. And generally that deposit amount is due once the hammer's fallen, okay? So you need to have it sitting in your bank account so you can transfer that across pretty well. I'd like to say immediately, but sometimes it's not immediately, but be prepared for that. Note, buying at auction requires thorough preparation, including completing all of your due diligence, such as building and pest inspections beforehand. The costs associated with this, along with the emotional intensity of the auction process, lead many buyers to avoid them altogether. I've got 3 forms here that the REIQ has created for buyers to use, and the sales agent may send them to you and they may not, depending upon the situation. This is a consent to receive electronic communication. And so the sales agent may ask you to sign this saying that you are happy for everything to take place electronically. And so it says here, by signing this document, the person or persons consent to the use of electronic communication. Okay, that is just a great way of knowing that you're likely to be signing the contracts digitally. Another document is this one, waiver or shortening of cooling off period. So if you are waivering your cooling off period, you can ask for the sales agent to give you a copy of this form so that you can supply it with a little bit more weight saying, I'm waivering my cooling off period and I'm submitting a contract under auction conditions. If you don't have one of those from the sales agent, you can ask me and I can send you one. It just adds a little bit more weight to your offer. Another one that you should be aware of is that a sales agent should ask you to sign this form to verify that they've made you aware that yours is not the only offer on the table, that the seller is considering more than one offer, and that you are aware that this is a multiple offer situation. Great. Just wanted to make you aware of those three little forms that can be quite helpful.